All right, welcome back to the Daily Facts, and we're going to get into part three of the Sidney Powell, Michigan lawsuit. So let's get right into it. Neither defendant is a legislature as required under the Elections Clause or Electors Clause. The legislature is the representative body which makes the laws of the people. Smiley, 285 U.S. 365. Regulations of congressional and presidential elections, thus, must be in accordance with the method which the state has prescribed for legislative enactments. ID at 367. See also Arizona State Legislator versus Arizona Independent Redistricting 576 US 787. While the Elections Clause was not adopted to diminish a state's authority to determine its own lawmaking processes, Arizona State Legislature 135S CT at 2677, it does hold states accountable to their chosen processes when it comes to regulating federal elections. A significant departure from the legislative scheme for appointing presidential electors presents a federal constitutional question. Bush 531 U.S. at 113, Rehnquist C.J. concurring. Smiley 285 U.S. at 365. And plaintiffs bring the action to vindicate his constitutional right to a free and fair election, ensuring the accuracy and integrity of the process pursuant to the Michigan Constitution, which states all Michigan citizens have the right to have the results of statewide elections audited in such a manner as prescribed by law to ensure the accuracy and integrity of elections. The Michigan Constitution, Article 2, Section 4, further states all rights set forth in this subsection shall be self executing. This subsection shall be liberally constructed in favor of voters' rights in order to effectuate its purposes. Based upon all the allegations of fraud, statutory violations, and other misconduct, as stated herein and in the attached affidavits, it is necessary to enjoin the certification of the election results pending a full investigation and court hearing, and to order an independent audit of the November 3rd, 2020 election to ensure the accuracy and integrity of the election. Legal background, relevant provisions of the Michigan Election Code and election canvassing procedures. Michigan law requires Secretary Benson and local election officials to provide designated challengers a meaningful opportunity to observe the conduct of elections. Challengers representing a political party, candidate, or organization, interested in the outcome of the election provide a critical role in protecting the integrity of elections, including the prevention of voter fraud and other conduct, whether maliciously undertaken or by incompetence, that could affect the conduct of the election. Michigan requires Secretary of State Benson, local election authorities, and state and county canvassing boards to provide challengers the opportunity to meaningfully participate in and oversee the conduct of Michigan elections and the counting of ballots. Michigan's elections of provide that challengers shall have the following rights and responsibilities. An election challenger shall be provided a space within a polling place where they can observe the election procedure and each person applying to vote. MCL 168 733. An election challenger must be allowed opportunity to inspect poll books as ballots are issued to electors and witness the electors' names being entered in the poll book. MCL 168733. An election challenger must be allowed to observe the manner in which the duties of the election inspectors are being performed. MCL 168733. An election challenger is authorized to challenge the voting rights of a person who the challenger has good reason to believe is not a registered elector. MCL 168733. An election challenger is authorized to challenge an election procedure that is not properly performed. MCL 168733. An election challenger may bring to an election inspector's attention any of the following: 1, improper handling of a ballot by an elector or election inspector; 2, a violation of a regulation made by the Board of Election Inspectors with regard to the time in which an elector may remain in the polling place; 3, campaigning and fundraising being performed by an election inspector, other person covered by MCL 168744, and or 4, any other violation of election law or other prescribed election procedure. MCL 168.733. An election challenger may remain present during the canvass of votes and under the statement of returns is duly signed and made. MCL 168733. An election challenger may examine each ballot as it is being counted. MCL 168.733. An election challenger may keep records of votes cast and other election procedures as the challenger desires. MCL 168733. An election challenger may observe the recording of absentee voter ballots on voting machines. MCL 168.733. The Michigan legislature adopted these provisions to prevent and deter voter fraud, require the conduct of Michigan elections to be transparent, and to assure public confidence in the outcome of the election, no matter how close the final ballot may be. Michigan values the important role challengers perform in assuring the transparency and integrity of elections. For example, Michigan law provides it is a felony punishable by up to 2 years in state prison for any person to threaten or intimidate a challenger who is performing any activity described in Michigan law. MCL 168734. It is a felony punishable by up to 2 years in a state prison for any person to prevent the presence of a challenger exercising their rights or to fail to provide a challenger with conveniences for the performance of their duties. MCL 168734. The responsibilities of the challengers are established by Michigan statute. MCL 168730 states: 1, at an election, a political party or an organization interested in preserving the purity of elections and in guarding against the absence of the elective franchise may designate challengers as provided in this act. Except as otherwise provided in this act, a political party or interested organization may designate not more than 2 challengers to serve in a precinct at any one time. A political party or interested organization may designate not more than 1 challenger to serve at each counting board. 2, a challenger shall be a registered elector of this state, a candidate for the office of delegate to a county convention may serve as a challenger in a precinct other than the one in which he or she is a candidate. 3. A challenger may be designated to serve in more than one precinct. The political party or interested organization shall indicate which precinct the challenger will serve when designating challengers under subsection 1. If more than one challenger of a political party or interested organization is serving in a precinct at any one time, only one of the challengers has the authority to initiate a challenge at any given time. The challengers shall indicate to the Board of Election Inspectors which of the two will have this authority. The challengers may challenge this authority and shall indicate the change to the Board of Election Inspectors. Secretary Benson and Wayne County violated the provisions of Michigan law and violated the constitutional rights of Michigan citizens and voters when they did not conduct this general election in conformity with Michigan law and the United States Constitution. The canvassing process in Michigan. Michigan has entrusted the conduct of elections to 3 categories of individuals: a board of inspectors, a board of county canvassers, and the board of state canvassers. The board of inspectors, among its other duties, canvasses the ballots and compares the ballots to the poll books. See MCL 168.801. Such canvass shall be public, and the doors to the polling places and at least one door in the building housing the polling places and giving ready access to them shall not be locked during such canvass. The members of the Board of Inspectors, one from each party, are required to seal the ballots and election equipment and certify the statement to return and tally sheets and deliver the statement to return and tally the ownership city clerk, who shall deliver to the probate court judge. As you can see, these are all linked together. So it's several words, but it's all linked together. So it takes time to read through that. So probate court judge, who will then deliver the statement of returns and tally sheet to the Board of County Canvassers. MCL 168.809. All election returns, including poll list, statements, tally sheets, absent voters, return envelopes bearing the statement required to cast an absentee ballot, must be carefully preserved. MCL 810 and 168.811, emphasis added. After the Board of Inspectors completes its duties, the Board of County Canvassers is to meet at the county clerk's office no later than 9 a.m. on the Thursday after the election. November 5th, 2020 is the date for the meeting. MCL 168.821, the Board of County Canvassers has power to summon and open ballot boxes, correct errors, and summon election inspectors to appear. Among other duties and responsibilities, the Board of County Canvassers shall do the following provided in MCL 168.823. The Board of County Canvassers shall correct obvious mathematical errors in the tallies and returns. The Board of County Canvassers may, if necessary for a proper determination, summon the election inspectors before them and require them to count any ballots that the election inspectors failed to count, to make correct returns in case, in the judgment of the Board of County Canvassers, after examining the returns, poll lists, or tally sheets, the returns already made are incorrect or incomplete, and the Board of County Canvassers shall canvass the votes from the corrected returns. In the alternative to summoning the election inspectors before them, the Board of County Canvassers may designate staff members from the county clerk's office to count any ballots that the election inspectors failed to count. To make correct returns in the judgment of the Board of County Canvassers, after examining the returns, poll list, or tally sheets, the returns already made are incorrect or incomplete, and the Board of County Canvassers shall canvass the votes from the corrected returns. When the examination of the papers is completed or the ballots have been counted, they shall be returned to the ballot boxes or delivered to the persons entitled by law to their custody, and the boxes shall be locked and sealed and delivered to the legal custodians. The County Board of Canvassers shall conclude the canvass at the earliest possible time, and in every case no later than the 14th day after the election, which is November 17th. MCL 168.822. But if the Board of County Canvassers fail to certify the results of any election for any officer or proposition by the 14th day after the election as provided, the Board of County Canvassers shall immediately deliver the Secretary of the Board of State Canvassers all records and other information pertaining to the election. The Board of State Canvassers shall immediately and make the necessary determinations and certify their results within the 10 days immediately following their receipt of the records from the Board of County Canvassers, MCL 168.822. The Michigan Board of State Canvassers then meets at the Secretary of State's office the 20th day after the election and announce its determination of the canvass, not later than the 14th day after the election. For this general election, that is November 23rd and December 3rd, MCL 168.842, there is provision for the Secretary of State to direct an expedited canvass of the returns for the election of electors for president and vice president. Okay, we're going to stop there and we'll pick up very, very soon on part 4. Thank you for stopping by the Daily Facts. Do like, share, subscribe, and leave a comment below, and we'll talk again soon. Bye.